Let me speak to you today about a judgment that sits at the heart of one of the most litigated and emotionally charged provisions under GST, Section 16(2)(c). And to truly appreciate what the court has done in this case, we must understand the tension that has existed in our tax system for decades. Under the GST framework, input tax credit is not just a benefit, it is the backbone of the entire system. The promise of GST was simple: eliminate cascading, ensure seamless flow of credit, and tax only the value addition. But this promise comes with conditions, and one of the most controversial among them is Section 16(2)(c), which says that a recipient can claim ITC only if the supplier has actually paid the tax to the government. Now, at first glance, this seems logical. The government should not lose revenue, but look at it from the perspective of a taxpayer. You have purchased goods or services, you have paid the tax to your supplier, you have a valid invoice, and you have used the goods in your business, and yet your credit is denied because the supplier, over whom you have no control, failed to deposit the tax. This is the precise conflict that came before the Karnataka High Court in the case involving Instacart Services Private Limited. Instacart, as many of you know, is engaged in logistic services supporting e-commerce sellers. They challenged the constitutional validity of Section 16(2)(c) and also Rule 36(4), arguing that the law imposes an impossible burden on the recipient. Their case was not that they had done something wrong. In fact, their entire argument rested on the fact that they had done everything right, but were still being penalized for the failure of their suppliers. They argued that such a provision violates fundamental constitutional principles. It is arbitrary under Article 14. It interferes with the freedom to carry on business under Article 19(1)(g). It goes against Article 265 because tax cannot be collected except by authority of law. And importantly, it impacts property rights under Article 300A. Because input tax credit, once validly earned, becomes a vested right. Interestingly, they relied on 71 judgments of various high courts as well as Supreme Court to support their argument. But what makes this judgment particularly interesting is not just the arguments, it is the way the court approached the issue. The court did not treat GST in isolation. Instead, it drew a direct line from the VAT era to GST, recognizing that this issue is not new. It is a recurring conflict in indirect tax jurisprudence. The court relied on earlier principles laid down during the VAT regime. One of the most important among them is the Karnataka High Court's own decision in Rajesh Jain, where it was held that once the purchasing dealer proves that he has paid the tax to the seller and the transaction is genuine, the denial of input tax credit is not justified merely because the seller failed to deposit the tax. This idea was further strengthened by the Delhi High Court in the landmark decision of on-quest merchandising, which was later affirmed by the Supreme Court in Arise, India. The reasoning there was very clear and very powerful. The law cannot expect a taxpayer to do the impossible. A purchaser cannot be expected to ensure that the seller deposits tax with the government, nor can the purchaser monitor the seller's compliance, especially when such information is not even accessible. The Karnataka High Court in this case embraced that line of reasoning. It acknowledged that Section 16(2)(c), if applied literally, would place an onerous and practically unworkable burden on the recipient. It would require the recipient to ensure something that is completely outside his control. At the same time, the court was conscious of the need to protect revenue. It did not say that the provision is invalid in all circumstances. Instead, it focused on a more nuanced approach. The key lies in distinguishing between bona fide transactions and fraudulent ones. The court emphasized that where the recipient has acted in good faith, has complied with all statutory requirements and there is no allegation of fraud, collusion, or connivance, the benefit of input tax credit should not be denied merely because the supplier has defaulted. This is a very important shift in perspective. The focus moves from a mechanical application of the provisions to a factual examination of the transaction. The genuineness of the transaction becomes central. The conduct of the recipient becomes relevant. In other words, the court is saying, do not treat all taxpayers alike. There is a fundamental difference between a genuine business transaction and a fraudulent arrangement. The law must recognize that difference. Another significant aspect of the judgment is the reaffirmation of a long-standing principle in indirect tax law, that the seller is the person responsible for paying tax to the government. The buyer pays tax to the seller acts in a sense as an agent of the government. If the seller fails in that responsibility, the primary action should be against the seller, not the buyer. The court also highlighted a practical reality. The department has the machinery, the powers, and the access to information required to enforce complaints against defaulting suppliers. A purchaser does not have these tools. To shift that burden onto the purchaser would be both unfair and unrealistic. What the court effectively does is to read down the provision. It does not strike it down, but it interprets it in a manner that makes it workable and constitutionally valid. It ensures that the provision does not operate in a way that punishes honest taxpayers. For us as tax consultants, the implications are significant. This judgment strengthens the argument that input tax credit cannot be denied in a routine or mechanical manner. The department must go beyond mere non-payment by the supplier. It must examine whether the transaction itself is genuine. It must establish some element of wrongdoing or involvement on the part of the recipient. It also reinforces the importance of documentation and due diligence. While the court protects bona fide recipients, the burden initially lies on the taxpayer to demonstrate that the transaction is real, that goods or services were actually received, that payment was made, and that the supplier was registered entity at the relevant time. At the same time, this judgment does not provide a blanket shield. Where there is evidence of fake invoices, non-existent suppliers, or collusive arrangements, the protection will not be available. In such cases, the denial of ITC will still stand. So what we see emerging is a balanced framework. On one hand, the court prevents the misuse of Section 16(2)(c) to harass genuine taxpayers. On the other, it leaves enough room for the department to tackle fraud. In a larger sense, this judgment is part of a continuing dialogue between the courts and the legislature. The courts are reminding us that tax laws must be enforceable, but they must also be fair. They must protect revenue, but they must not do so at the cost of basic principles of justice. And perhaps the most important takeaway is this: the GST system cannot function on distrust. It was built on the idea of seamless credit and mutual compliance. If that system begins to penalize honesty and reward non-compliance, it defeats its own purpose. This judgment brings us back to that original promise. It tells us that while compliance is essential, it must be reasonable. And above all, the law must not demand what is impossible to perform. Thank you.